If you've lost someone close to you and are handling the estate, you may be wondering what the law requires, what forms to use, and what it means to probate someone's assets. In addition to the emotions surrounding your loss, you probably feel stress, even dealing with an estate, because of all the unknowns. The professionals at Heatherman Law are specialists in estate and probate management. We can eliminate a lot of your stress. I'm Patricia Heatherman, and I'll explain some requirements of estate managers, along with options for handling bank accounts, vehicles, and other property owned by the deceased. These topics just scratch the surface though, so I hope you'll see a probate specialist to get all your questions answered. If the deceased died testate, meaning with a will, his or her assets will pass to the beneficiaries in the will. Having a will does not avoid probate. If a person dies without a will, that's called dying intestate. In that case, heirs will receive the assets. Who qualifies as an heir depends on the family situation. Probate refers to the way an estate is processed through the legal system after a person dies, with or without a will. It guides the orderly transfer of an estate in the payment of debts and distribution of assets to beneficiaries or heirs as defined by Oregon statute. Whether you need to probate property depends on the value and type of property. If the deceased was the sole owner of real property with equity or had $25,000 or more in bank accounts, you'll probably need to probate the assets. If the deceased owned only tangible personal property like cars or other vehicles titled by the Oregon Department of Motor Vehicles, you may not need to probate these assets. If all the heirs can cooperate, obtain an inheritance affidavit from the DMV website for all the heirs to sign. This will allow for the transfer of ownership of vehicles. The Oregon Marine Board website has a similar form to transfer boats. For other tangible personal property like furniture, jewelry, guns, or gold bars, a probate may be warranted if the items are highly valuable. But in most cases, it is not cost-effective. Taking any tangible personal property from the home of the deceased could make you responsible for some of the debts. Basically, if you receive value from a deceased person, creditors can legally pursue you for up to the value you received. So be sure to document everything. Under Oregon law, bank accounts containing less than $25,000 total can be transferred with a bank affidavit that says you will pay funeral expenses and other debts out of the account. A copy of the death certificate must accompany the affidavit. Lately, we frequently see an estate consisting of a home that is worth less than the mortgage owed, a small bank account, and some tangible personal property, including a car. When asked how to handle this estate, I've advised clients to do nothing with the home because the mortgage company will foreclose on it. I encourage them to take what they want of tangible personal property, documenting each item carefully in case they have to deal with creditors. Use the bank affidavit to access the bank account and pay any debts possible, and use the DMV inheritance affidavit to transfer vehicles. Probate can be costly. However, you may incur personal liability if you don't take the right approach. The death of a special person can put enormous stress on a family. Resolution and closure come in many forms and many ways. My practice can help support you in this process. Every situation is unique, and of course this video does not serve as legal advice. I urge you to contact an attorney who is a probate specialist. If you need assistance in Central or Eastern Oregon, please give me a call. I'd be happy to help you.